Sir, I am very grateful to the honourable members who have expressed their opinion at length and expressed their concerns on this subject. Let me first of all assure this honourable House that the Central Bureau of Investigation is an extremely professional agency. As in all other cases, in this case, this government has not and shall not use the CBI for the purposes of any collateral purpose, either for a wrongful investigation against some individuals or for hushing up any particular case. Ever since this government came to power, this particular case has been discussed on several occasions in this house as also in the other house. My colleague Mr. Ravi Shankar Prasad mentioned that this government did not even ever think in terms of withdrawal of prosecutions which governments in past have thought of, because we wanted the law to take its own course. In fact, I do recollect reading statements by some of my friends on the other side that when the CBI prosecutor argued the case and said we have material against certain persons who are accused in this case, editorials were written, demands were made that because it is this CBI which is still pursuing the case against Mr. Advani and others, has said this in court, on this ground alone, Mr. Advani and others must resign from the government. But I do not know what changed. Maybe some news item appeared or some program appeared on some television, and a suggestion was made that section 120B has been dropped from the charge sheet against Mr. Advani and others, and a suggestion is made thereafter that because of this, the CBI has shown some favor as far as Mr. Advani and others are concerned. So I've been listening to a large number of our colleagues in this house. Mr. Sibal very eloquently and very in his own competent manner gave all the details of the facts. Let me just repeat some of the things that he said and add some of the things which were missed out. And it is my submission that on his factual narration of facts where I agree with him on a number of points, I am in the course of the last 2 days, when this house is also the other house and in the media we've debated this issue, whether there has been any effort to drop or delete section 120B, or whether this entire unrest is about the failure to surreptitiously add section 120B when it was not warranted.
You know it was not warranted. How can you say that?
Allow me, Mr. Sibal, to complete.
As a minister, you can't say that.
Allow me to complete.
No, I'm just saying.
Yes,
Minister,
let me.
Can you ever say in a public platform that 120B was not warranted? You're the law minister.
Well, Mr. Sibal, once I give you all the facts, you'll probably tend to agree.
What is the whole case about if you give the
Yes,
message?
yes.
No, the
Let
point.
me-
Sir, as a
you raise a
minister,
debate.
what is the message going?
Yes.
He just said it's for the court to frame the charge. Now he
Yes,
says
it
120B
was
is
for the
not
court to
warranted.
frame the charge, but I had said that yesterday, I repeat that today, it is for the court to frame the charge, but because sir, we are by proxy arguing what should be argued in court. That is why it can't be that Mr. Sibal gives all the facts and a reply to that should not be warranted.
Here, standing on the floor of the house.
Yes.
एक बार सुन तो,
I have not even opened.
सुन तो, let him complete. 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 Let him complete what did he say. आप वो कह रहे हैं, अपना आर्ग्यूमेंट दे रहे हैं, आप भी आर्ग्यूमेंट देते हैं. नहीं वो ठीक है, लेकिन अभी बोलने, अभी लेट हिम फिनिश.
हमने कहा है कि वो चार्जशीट फाइल करनी चाहिए, फिर कोर्ट फैसला करेगी whether it's warranted or not.
वो उसी पर बोल रहे हैं.
उसी उन्होंने कह दिया कि it's not warranted.
अब बोलने दीजिए आगे, क्यों क्या बैकग्राउंड बना रहे हैं. जैसे आप लोग बैकग्राउंड बनाते हैं वैसे बैकग्राउंड बनता है.
Sir, let me end this controversy which has been raised by only saying this.
ये कोई नहीं कर रहे हैं, बैठ जाइए आप.
Sir, let me end this controversy by merely saying, and on a fact which some of my very honorable colleagues may not dispute, whether 120B is warranted or not warranted, really the political process can't decide that. The government has no power to direct the CBI. The CBI, if it is satisfied that it is warranted, can state that in the charge sheet. If the CBI states that, it is still for the court to decide whether it is warranted or not. And if the CBI does not state that, then on the basis of the entire material, it is still open for the court to decide whether it is warranted or not. Sir,
Just answer one question.
He has clarified the whole position.
Sir, let us just enumerate what has happened in this case. After the incidents of 6 December, the CBI, or the UPCID, I'm sorry, filed, the CBCID filed a charge sheet in the court at Lalitpur on 27th of February 1993. When this charge sheet was filed, I need not go into the details of what my friend Mr. Sanjay Nirupam has argued, what kind of statement witnesses have made which were annexed to it. There was admittedly no charge under section 120B. Once there was no charge under 120B, that trial could have gone on. In the first instance, there was no BJP government in UP. The UP police could not have been accused of showing any bias towards the accused. UP was under president's rule. A very leading member of the Congress party was then the governor of UP. Mr. Narasimha Rao was the prime minister. The UP police, the CBCID, investigated the case, had a large number of voluminous statements, and regrettably for them, a large number of those statements also which had said that some of these accused persons were actually making appeals to the people not to touch the disputed structure. Now, I am not going to go into details of evidence. Sir, I am not going to read the evidence. I am not even going to refer to the evidence. I am merely suggesting a charge sheet is filed by the UP CBCID, and once that charge sheet is filed,
that has been referred in. So many members have referred about the CSBI.
Sir, we did not disturb anybody when they were speaking. Sir, if this becomes a practice of the House, that we listen to each one of them, and when we are to respond, this disturbance takes place, then do they want a situation where debate should be conducted in this manner? Well, I am answering all your questions if you kindly wait to have patience. Sir, once this charge sheet is filed, cognizance is taken by the judge. After cognizance is taken by the judge, something which is unprecedented starts happening in this case. There is a charge sheet which is on in the case, but then what Mr. Bharadwaj referred to at length, a larger charge sheet is filed before another court.
By whom? CBI.
When a larger charge sheet is filed before another court by the CBI, there is a particular procedure to be followed, and this procedure is of significance because even though 120B was not an offence against Mr. Advani and others in the original charge sheet, an effort is made to somehow subsume this charge sheet into the larger charge sheet, and a particular procedure is followed. Under the procedure under section 11 of the CRPC, state government's permission is required, a notification is required, consent of the High Court is required. Now in this case, a request is in fact made. The state government then, it was under President's rule, the governor was in charge, is requested kindly issue a notification so that the smaller charge sheet can now be subsumed into the larger charge sheet, and somehow 120B becomes applicable. There was no BJP, there was no Rajnath Singh, there was no Mr. Vajpayee, there was no Ms. Mayawati at that stage. UP was under President's rule. The central government was a Congress government. Still the governor's office goes into this question and gives several legal elaborate reasons in 1993 September and says a notification merging the two, subsuming one into the other cannot be issued. And the whole game plan of introducing 120B when it was not there in the first instance, stands defeated. Now, it's still a mystery to me. The governor's office says no, it can't be done. A notification is declined. High Court's consent under Section 11 is not taken. And yet they feel that merely because they have not been able to collect sufficient evidence against some leaders then in opposition, somehow an effort should be made to still subsume it, notwithstanding the mandatory requirement of law. And now you have an unprecedented situation that without complying with the Section 11 requirement, consent of the High Court, governor's permission,
This is again wrong. I may remind my learned friend, a notification was issued by the UP government. And state on this house that no notification was issued. Which is very unfortunate that the minister is stating a fact which is contrary in the charge sheet filed, which says that the state government notification was issued. He should withdraw his statement.
I have to read out that notification and number.
And that notification was never challenged, never said.
Sir, I'm very grateful. I'm very grateful to my friend Mr. Sibal for having raised this question.
मैं
The
अलाउ कर
governor's
दूं
office.
अलाउ कर दूं
Notification.
नहीं वो ठीक है नहीं वो जो अब आप
नहीं, कोई जरूरत नहीं। मैं
ठीक है समझ गया
सर
ठीक है बैठिए
सर भारद्वाज जी, आप अगर प्रतीक्षा करें तो मैं पूरे तथ्य दूंगा। आप उससे असहमत नहीं होंगे क्योंकि आप उस वक्त कानून मंत्री थे। आप मुझे कंप्लीट करने दीजिए, आप असहमत नहीं होंगे। सर आप भारद्वाज जी मुझे कंप्लीट करने दीजिए, थोड़ा पेशेंस रखिए। सर आई एम नॉट Sir, I have not accused anybody, but I can't understand the excitement. I have not even placed the facts. On 9/9/93, the governor's office declined the consent to issue a notification for transfer of case based on FIR number 198 of 92 from Raebareli to Lucknow. This was declined. High Court consent was not taken. Thereafter, and this is where the whole mystery lies, without the consent of the governor, without the consent of the High Court, somebody still issues a notification. Somebody...
तो बोलने दीजिए बोल रहे हैं ना तो बोल रहे हैं वो जो आप बोल रहे हैं वही तो बोल रहे हैं
पहले सर पहले
प्लीज डोंट इंटरप्ट
मिस्टर सिब्बल,
प्लीज डोंट इंटरप्ट
अगर आप
नहीं देखिए आपको किसी ने इंटरप्ट नहीं किया और मैं ऐसा समझता हूँ कि इंटरप्शन से काम नहीं चलेगा
सर the initial notification creating the court at Lucknow dealt with 48 cases and not the 49th case, which was Mr. Advani's case in Raebareli. The decision was a conscious decision. And let me just read out one paragraph what the UP government has told the Supreme Court in this regard. By this notification dated 9/9/93 was a conscious decision taken by the government after approval of the advisor to the governor on the legal advice.
वो कोई कोर्ट का
Sir, I need protection. The house can't be run in this manner that every 30 seconds Mr. Sibal will get up. We don't do it when you do it. I am sorry.
ये यूं मत करिए, ये गलत बात है। ये क्या पढ़ रहे हैं? तो पढ़ रहे हैं।
This is not a way to debate the issue.
मैं यहाँ टेबल पर रखवा देंगे।
Conspiracy was to bring in.
हाँ टेबल पर रखवा देंगे। चार्जशीट नहीं गवर्नर का है वो गवर्नर यू ऑल्सो रेफर्ड आपने रेफर किया गवर्नर का
Sir, my friend wants to know what I am reading. I am reading the affidavit of the UP government by the special. Sir, I have not said so. Lack of comprehension of my friend doesn't mean that I have said so.
ये तो उचित नहीं है
Sir,
Notification is there.
Sir, if somebody deliberately chooses to misunderstand, I am not going to take as a reflection on what I have to say. I seek protection that I be allowed to complete my.
भाई जो डॉक्यूमेंट पढ़ रहे हैं नहीं पढ़ रहे हैं, ऑथेंटिकेट करें या नहीं करें, लेकिन हाउस में बोल रहे हैं और हाउस में बोल रहे हैं तो रिस्पॉन्सिबिलिटी के साथ बोल रहे हैं। नहीं, ऐसा नहीं है।
गवर्नर ने मना कर दिया, हाईकोर्ट ने मना कर दिया और
वो देखें
Sir, if my friends will permit me, we have heard them patiently. I am, sir, merely because the governor's advisor's order makes the position uncomfortable for them, that doesn't mean that we should be prevented from speaking.
Please give us protection. He is quoting from a document which is not available to the House.
Yes, I'll place it. Sir, I'll abide by your ruling on the matter. If I am permitted to clarify, then whatever ruling the Honorable Chairman gives, I'll abide by it. Yes, sir, I am only talking of CBI. It is not a case of taking out 120B. There are efforts to surreptitiously bring in 120B at place.
Not the merits of the case.
Sir,
क्या भाई क्वेश्चन इतना सा
yes.
देखिए
I am defending the role of CBI. And therefore I am defending the role of the CBI. What the CBI has done in not adding 120B is a correct decision.
ठीक, आगे चलिए
Sir,
If he is reading from any paper, he'll have to authenticate that. I would have objection.
वो आपका जो कह रहे हैं सही है।
sir, all right, I will authenticate that. All right, authenticate that. And this authentication will be reasonably embarrassing to you. Yes.
You please authenticate this.
I'll authenticate what I want to authenticate.
ठीक है।
Sir, the stand of the UP government is that, sir, the stand of the UP government is on 9/9/93, a notification was issued with regard to 48 cases and Mr. Advani's case was kept out. This was a conscious decision of the office of the governor whose advisor signed the note. Thereafter, it is a serious matter. It's a serious matter as to how this charge sheet got combined without the governor's, in violation of the governor's order. It is a serious matter. It is a serious matter.
माननीय सदस्य, नहीं ये माननीय सदस्य ये उचित नहीं होगा, ये उचित नहीं होगा। आपने जब चार्जेस लगाए बोलिए आप।
Sir, I reiterate that when the matter went to the highest office in the state of UP as to whether the two charge sheets, one where 120B was proposed and one where 120B was not there, obviously because evidence was lacking, can be combined, the advisor to the governor, after detailed reasons, approved the file saying the two cannot be combined for various legal reasons he set out. Therefore, a conscious decision was taken that Mr. Advani's case, number 198, could not be merged with the RC1 in Lucknow. Notwithstanding that, the other requirement of section 11 was High Court's permission was to be taken. But the pressure was somewhere, because of otherwise lack of evidence, that somehow the two must be combined. And therefore, notwithstanding the fact that governor's office had declined it, without taking the permission of the governor, without taking the permission of the High Court which was necessary, still at a junior level a notification was issued. And this is what in its affidavit before the Supreme Court, the UP government has said. that this notification dated 9/9/93 was a conscious decision taken by the government after approval of the advisor to the governor on the legal advice given by the law department, approved by the law secretary, not to include the case crime number 198 of 92 in the notification dated 9/9/93, because there was already a court of special magistrate established at Raebareli to try the case crime number 192. Therefore, if any amendment was made in the notification dated 9/9/93, the approval of His Excellency the Governor and the consultation of the High Court, which was mandatory, was not done. Now, sir, what does this prove? All that it proves is that there were two charge sheets, one where 120B was there, where Mr. Advani is not an accused, the other where Mr. Advani is an accused and there is no 120B. Mr. Advani's charge sheet had to be subsumed into the larger charge sheet. A procedure under law had to be gone through. That procedure could not be complied with because the governor did not give consent. The High Court was not approached. Therefore, in violation of law, through the back door, 120B was introduced into the case by merging the two. The trial started, the charge was framed, the matter went to the High Court. The High Court said, as far as the charge is concerned against all the accused, the charge is maintainable. But what happens to those accused, including Mr. Advani, who were accused in crime number 198? The High Court says, while charge against 48 cases is upheld, in respect of the notification of 9/9/93, the impugned order is set aside in respect of crime number 98 of 1992. Therefore, the framing of charge against him under 120B and others was set aside. The state had two options. The first option was, you can now issue a notification and correct the whole procedure. The second option was, you set up the court is already there in Raebareli and you set it up. We are today discussing the role of CBI. What does the CBI do after this? Even though governor had denied permission in 1993, the CBI again goes back to the state government and says, please issue a notification. Was the CBI colluding when it still wanted a notification merging the two? It tried one option under the judgment. The state government said, there are detailed reasons dated 9/9/93 given by the advisor to the governor that these two can't be merged. These are different charge sheets, the evidences are different, the accusations are different, so a merger can't take place. Therefore, we don't see any reason why to disagree with that order. We are instead constituting the court in Raebareli. So the state government constitutes the court in Raebareli, the trial begins. Once arguments on charge are today going on, the CBI prosecutor vehemently argues, he has concluded his arguments, that charge under these sections must be framed. On the first day, my friends in the opposition make a statement, oh, CBI is saying charge should be framed. When CBI is saying this, Mr. Advani must resign. And suddenly somebody, without knowing all this background, comes up with some article in a newspaper, well, why is 120B not there? So now the other rhythm starts, well, CBI is colluding to save you. Sir, whether CBI is seriously pursuing or colluding, eventually the judge of this can't be this honorable house, can't be members polarized on party lines. It has to be the judge, it has to be the High Court, it has to be the Supreme Court. Due process of law requires that when case is being argued, the charge has to be framed or not to be framed by the judge. We don't prejudice the trial by having a parallel debate on the subject. And the insistence for this debate was an insistence to create an environment which is prejudicial to a fair trial. So this is something which ought to have been resisted. My respectful submission, sir, is now that these facts and the governor's office advisor's order is before us, and the governor was not a BJP governor, the governor today is a leading member in the front benches of the Congress party in this house. He is the General Secretary of the Congress. Today, when this was the governor's order that these two can't be merged into one, his advisor's order, you find fault with Rajnath Singh and Mayawati for not merging the two cases together, when your own governor also, under legal advice, said these two can't be merged. Sir, I get an uneasy feeling that this is not a case where 120B has been dropped. 120B was never there in Raebareli. The Raebareli charge sheet continues. 120B is still not there. There is no question of dropping or diluting the charge. An effort has been made. If there was a conspiracy, it was a conspiracy somehow to bring in 120B. Somehow it has not succeeded, and the entire grievance is really because of that. And it is for this reason, sir, we oppose this motion.